I think we're heading toward a system of international or global justice. We're not there yet, the sort of days that we had in the 1990s when the international ad hoc courts were established and the ICC was established, and when some chiefs of state and other powerful individuals were brought to account, I think gave us a lot of hope that by the time we got to 2016, we'd be well on the way to an international system of justice. But there have been a lot of pushback, obviously, from leaders who want to be able to preserve their own power, want to continue impunity, and challenges in the fact that some of the courts that had the greatest success, the Yugoslavia Tribunal, the Rwanda Tribunal, the Sierra Leone Tribunal, are basically closed now. I mean, there's a Mladic case just finishing in The Hague and a few appeals, but otherwise those courts are gone, and they had 30 or 40 judges working in them, making decisions on all sorts of questions: what genocide really was, defining the laws of war and the laws of armed conflict in ways that they'd never been fully defined before. There were always questions for the Red Cross on whether this was a crime or that was a crime, and it's really been laid out. And then the whole area of crimes against humanity, which came to us originally from Nuremberg, has been fleshed out enormously with crimes like sexual slavery and the Special Court for Sierra Leone, forced marriage, and other horrendous violent acts being recognized and prosecuted as crimes against humanity. That whole phase is now coming to an end, and what we have now is the ICC, which doesn't have as much sort of legal authority behind it as the ad hoc tribunals, because they operated under the United Nations Charter, and their orders were binding on all states in the world. The ICC is only binding on the 124 countries that have signed up, and some of them don't fully honor their obligations, and there's really nothing that can be effectively done to them, unlike in a case of a Security Council situation where a country can be sanctioned for violating something or violating a resolution that passed the Security Council. And even when the Security Council has referred cases to the ICC, it hasn't provided that the orders are binding on anything other than the Rome Statute countries and on the situation country. Others are simply urged to cooperate. And that institution has also been burdened by some very complex procedures. It has to go through basically 3 hearings almost before it even gets to set a case for trial. Unlike the ad hoc tribunals, we were able to just file an indictment application to a judge who could approve it ex parte. Then if we could arrest the guy, he'd be in, plead guilty, not guilty, we'd set it for trial. In the ICC, you have to get a court order to open the case, you have to get a court order for the arrest warrant, and a very complex procedure. And then even after you arrest the guy, which is very hard to do because there's not a lot of cooperation globally in those efforts, you have a confirmation hearing in which the defense appears, and in several cases, at least 3 times at the ICC, the prosecutors lost the case, even at the indictment phase. So as a result, we've got a court that's been in business for now 14 years, really up and active for 12, but with 4 convictions so far, and really only 4 cases pending. And so it's not I mean, there are other people that are fugitive, but in terms of who's before the court, that's where it is now. So that's not much of a global system. What you need is, of course, that there are trials going on in other places, and the ICC has this principle that it's a court of last resort, and that it's encouraging states to prosecute their own. And I also think it's consistent with having other courts at the intermediate level that states help set up, like hybrid courts or mixed courts. We haven't done much of that since the Sierra Leone court and the Cambodia one, but a number of those are now coming online. So as I say, there's not a lot of punch in the global system right now. Where I see possibilities is the ways that the international tribunals have excited and activated civil society everywhere. And they're working to gather documents, pushing for changes in laws at the domestic level. There are countries that have established their own war crimes units for third country prosecutions. There are a lot of laws that permit victims to begin cases. And in a way, that kind of citizen demand which is harder for leaders to push back against because it's not coming in from external elements, it's coming in from below, I think, with assistance of international actors, NGOs, and others who train and work with these folks, but also provide the assistance and the legal basis for what they're doing. I think that can get us, in a way, a third wave of international justice. But the wave has not yet come close to cresting. Well, I think the future of international criminal law will be at the local level, or as I won't necessarily call it regional, but at the mixed or hybrid level. I mean, there's talk of an African regional court. I tend to be somewhat pessimistic that that'll come online because these courts are very expensive. And starting a court from scratch like that and getting countries to actually ratify it, none have yet, I think will take a long time. It'll also have a broader jurisdiction than just war crimes and crimes against humanity, human trafficking, terrorism, money laundering, piracy, other things, all of which are important, but obviously that means that it'll be spread very, very thin. So, and the resources within the African Union, unless it receives external funding, haven't been sufficient for the African Union to support itself from dues in Africa for its other operations. So I think this is going to be a tough one to go with. On the other hand, I think the hybrid approach or the mixed approach, which builds on the national system, and national systems exist everywhere, some stronger than others, but you do have court buildings, and you do have judges, and you do have police, and you've got a permanent structure there. What you sometimes lack is the capacity to prosecute these kinds of cases, and the will to do independent trials. I mean, you get cases where in some countries, of course, they're very happy to punish the people maybe from a previous regime, et cetera, and even deny them a fair trial, et cetera. So there's a lot of will, potentially. No will, however, to prosecute any of their friends. And getting a court that's sufficiently independent that can talk back to power and decide cases fairly, and is robust enough in terms of its reputation and strength and the ways in which judicial police and others follow its orders, that it can actually build cases, is a tall order. And that's one of the advantages that one gets if you bring in internationals with international support and with external government providing assistance. May not be required to do it for a long period of time. In Bosnia, for instance, a mixed court there has prosecuted scores of cases from the crimes were committed in Bosnia in the 1990s. The Hague, of course, the Yugoslavia Tribunal has prosecuted some of the big fish, but it's going after the middle fish, so to speak, and it's brought in convictions for genocide at 1/20th the cost of the cases in the Hague, and it has judges from each of the communities, and it had for 6 years international judges, but they were phased out. So I think that kind of model, which of course then strengthens the national system when they leave, they're more confident, more resourced, the reputation is stronger, all of that kind of thing. I think because it builds on something that's already there and leaves something behind in the place where we naturally expect law to be centered, which is in the state. I think that kind of approach is the one that makes more sense in terms of dealing with particularly serious cases of atrocity crime. Keep in mind, however, that the challenge is that hybrid courts always require the state itself to agree to them. Usually require then, in the case of hybrids, UN or the AU entering into an agreement. In the case of mixed courts, it may require a cooperation of donors. But fundamentally, if the state doesn't want it, then you don't have it. At the moment, in South Sudan, there's a peace agreement that provides for a hybrid court. On the other hand, the key provision in the peace agreement, which was the power sharing between President Kiir and Vice President Machar, has broken down, and Machar has been fired and removed. But that peace agreement that was signed last year did provide that there would be a hybrid court. And it was essential to getting public support for the agreement to have a hybrid court. Now it's up to the AU to work with the authorities in Juba and others in civil society to get this going. And of course, if the government in place in Juba, led by President Kiir, don't want it to happen, it will be a challenge to actually set it up. I think the Burundi case was not unexpected. You had a government that's been thumbing its nose at, frankly, the rest of Africa in terms of what's happening there with the president seeking an unconstitutional third term and a lot of violence. Now, it may not be to the ICC level, but 400 or 500 civilians have been killed. When I think of ICC cases, I think of thousands being killed. But clearly there's the danger that this could erupt at any time into horrendous violence. And Burundi is a country that has seen massacres and crimes in the past that have taken truly hundreds of thousands of victims in the 70s and then again in the 90s. And so we're really concerned about that. And obviously, withdrawing from the ICC, it doesn't take the ICC out of the picture. The prosecutor has a preliminary examination. She could open a case even if Burundi leaves the court formally a year from now and she doesn't file a case for 3 years. The court has jurisdiction because Burundi was a state party when the crimes were committed. On the other hand, passing a law and getting out from under the court will make it very hard to get cooperation in the country. Probably would have been hard anyway. A lot of the evidence can be developed, however, by people that have left the country and by people who brought evidence out, et cetera. So it's not impossible. And Burundi is obviously a very small country. Probably their dues to the ICC are probably only $5,000 a year or something like that. But South Africa, which is the country with the second largest economy or gross national product, I think, in Africa after Nigeria, its loss, I think, is really hard on the court. And given South Africa's leadership on these issues, the leadership of people like Richard Goldstone or Nabi Pillay, who was in fact a judge here in Arusha, then later a judge for 6 years of the ICC, and then High Commissioner for Human Rights, and others from every community in South Africa, for it to withdraw, I think, is extremely unfortunate. We hope that, as Richard Goldstone has suggested, he believes and others do that the executive can't do this on its own, and the courts in South Africa have shown tremendous independence, and it may be that it won't happen unless there's parliamentary approval, though that could nonetheless be voted with the ANC in power if they really make it a very strong political issue. So I'm not hopeful that they'll reverse this, and of course it may also lead other countries to withdraw. It won't be the end of the court. There's strong support for the court in other parts of Africa, and West Africa in particular. And of course every country in South America is a member, every country in the European Union is a member. There's support from Korea, Japan, Australia, other countries in the Asia-Pacific area. So I see the court still playing a very key role, but the perception will be that the court, when it takes on tough cases and goes after top leaders, gets such pushback that it can't really afford to do that, and that diminishes what I hope would be the deterrent effect that would prevent people from committing these crimes in the first place.